I'll call this meeting to order. This is a Knoxville City Council workshop on home rule in Tennessee. We'll get started with the Pledge of Allegiance led by Councilmember Ryder.
Face the flag. Face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you. Mr. Johnson, please call the roll.
Councilwoman Fugit, Councilwoman McKenzie, Councilwoman Parker, Councilwoman Ryder.
Here.
Vice Mayor Roberto.
Here.
Councilwoman Singh.
Here.
Councilman Smith.
Here.
Councilwoman Testerman.
Here.
And Councilman Thomas. 6 present, Vice Mayor.
Thank you very much. All right, so we'll get started on our topic today, which is home rule. Home rule is a matter in which all of us on City Council, as well as all of us that make Knoxville our home and citizens across the state, have a special interest in. Each of us have an obligation to educate ourselves about this topic. The topic that we're talking about today reminds me of a quote that I think everyone's familiar with from Howard Baker, who had said at one point, "I subscribe to the theory that the best government is the closest government wherever possible." And I think that really encapsulates a lot of the discussion that we're going to have this evening. But tonight we're going to focus on home rule in Tennessee because that's a subject that certainly has been in the news a lot of late, and we definitely want to be better educated on it. To help us better understand home rule, we've assembled a distinguished group of experts who are visiting with us tonight, some in person and some virtually. Tonight, City Council welcomes former Tennessee Attorney General Bob Cooper, welcome. Davidson County Clerk Brenda Wynn, welcome. And participating remotely, we have Metro Nashville Law Director Wally Dietz. Welcome, Mr. Dietz, Director Dietz. So let's go ahead and get started. General Cooper, thank you for taking the time to travel to Knoxville and join us today, and we look forward to your presentation.
Thank you, Mr. Vice Mayor, and pleasure to be here, pleasure to be with the council. This is, I feel honored to be with this group who are talking to you today. Let me say that my goal here is to address and go into the history of home rule in Tennessee, because I think to understand what's going on today, you really need to go back to when home rule was initiated and even before that. And I will say that really my knowledge of this is more recent than my time as the State Attorney General. I also, prior to Mr. Dietz, served as the law director for the city of Nashville and had some significant litigation involving the Home Rule Amendment and the piece of state legislation. So that's a little bit of the context of what I'm bringing to this. But to talk about home rule, let's first go back to the days before home rule. And until 1953, the Tennessee General Assembly could basically do whatever it wanted to do with local government. And let me give you a couple of examples. In 1879, the General Assembly revoked the charter of the city of Memphis, abolished all of the city offices, took ownership of all the city property, and created a new government, creatively called the taxing district, which had 3 commissioners, 2 of which were appointed by the governor. So that's a fairly radical restructuring of local government. In Nashville, while never something quite that drastic, the General Assembly repealed the city of Nashville's charter 3 times. And in one of those repeals, the legislature transferred the mayor's power to the chief of police, who had been appointed by the previous mayor, not the current mayor that they ousted. So how could the General Assembly do this? Well, that's because there was nothing in the state constitution to stop them from doing that. Cities were recognized as, quote, creatures of the state that existed at the General Assembly's discretion. Counties, at least, were recognized in the state constitution, but only as geographic areas that had certain constitutional officers. Operationally, the counties were really just considered agencies of the state that performed state functions. For example, law enforcement through the constitutional office of sheriff, tax collection through the tax assessor, record keeping through the county clerk. And so therefore, the counties were largely at the state General Assembly's mercy also. So why would the General Assembly get involved in these things? Well, many of these private acts appear to have been generated by local political conflict. You know, Clausewitz liked to say that war is the continuation of policy by other means. Well, these private acts were often continuation of local policy wars by other means, i.e. through their legislative delegations. But as cities and counties grew, this type of legislative interference became increasingly untenable. Not only were these local bills disrupting the normal function of government, but also the cities needed the ability to respond to new urban challenges without having to go back to the state for permission. And the faster growing counties were becoming more like cities, dealing with planning, zoning, public health, and they likewise needed more autonomy and flexibility. So this all came to a head in 1953, when the state had its first constitutional convention since 1870. And while the 53 convention considered several issues that lengthened the governor's term from 2 to 4 years, that abolished the poll tax, the driving force behind that convention was home rule. And the convention drafted and passed 8 amendments. 3 of those amendments were to Article 11, Section 9 of the Tennessee Constitution and are collectively known as the Home Rule Amendments. So let me go through those quickly. First, there's the Home Rule for Municipalities Clause. That was Amendment 7. It related to optional home rule for cities, and it created a constitutional right for a city like Knoxville to adopt and amend its own charter of government without going through the General Assembly. Then there was the Consolidation Clause. That was Amendment 8, related to consolidation of city and county functions, which led to the creation of the metropolitan government of Nashville and Davidson County in 1963. And then there was what is the heart of the Home Rule Amendments, the Local Legislation Clause. It's the provision that has generated the most litigation. It's Amendment 6 from the convention, and it relates to home rule for cities and counties as to local legislation. And that clause has 2 parts. The first part absolutely prohibits so-called Ripper bills. Now, that's not my term. That was the term that the delegates to the 1953 convention talked about. It basically removed the General Assembly's power to pass any legislation that removes an incumbent from local office, abridges the incumbent's term, or alters the incumbent's salary prior to the end of the term. So that's just an absolute prohibition. Can't do it. The second part addressed all other local bills. And it says that any local bill applicable to a particular city or county in its governmental or proprietary capacity, which essentially means any capacity, must be approved by the affected jurisdiction either by voter referendum or by the local legislative body. If there is no such local approval in the bill, then the bill is void. Now, it's no exaggeration to call the 1953 Home Rule Amendment a revolution in Tennessee governance. And the Tennessee Supreme Court makes 2 key points about that in a 2001 opinion. The court recognizes that, first, quote, the whole purpose of the Home Rule Amendment was to vest control of local affairs in local government. And it explains that this local control exists because cities and counties now, quote, derive their power from sources other than the prerogative of the legislature, i.e., They derive that authority from the Constitution itself. Now, it's important to note here that while the Home Rule Amendment gives local governments more autonomy, it does not make them independent of the state. The delegates to the 1953 convention were very clear on this point. Even after the adoption of the Home Rule Amendment, local governments remain subject to laws of general application. Now, litigation under the local legislative clause began almost immediately after its adoption, and cases went to the Tennessee Supreme Court fairly regularly through the 1970s, but really became pretty rare after the early 1990s. Now, this is a gross generalization, but this initial wave of local legislation clause cases, kind of like what was going on before Home Rule Amendment, mostly arose because of political disagreements at the local level, such as a lawsuit invoking the Home Rule Amendment regarding the hospital authority in Chattanooga-Hamilton County, or expanding the authority of General Sessions judges in Gibson County to alleviate a state court backlog. These were not political disagreement. These were local issues, not political disagreements between local government and the state. But that is not the case today. Now it's political differences between the state and local governments that are driving legislation and therefore this litigation. Now, those differences did not initially implicate the Home Rule Amendment because the bills on the whole were drafted as general legislation that applied statewide, even if the bill was motivated by what a particular city had done. And we've seen this sort of statewide preemption of local ordinances dealing with minimum wage or discrimination in contracting or municipal broadband, those sorts of things. But, and Director Dietz will talk more about this, the bills that were passed earlier this year related to the Metro Council and to Metro government in Nashville, Metro boards. It is hard to argue that they were anything but targeted specifically at Metro Nashville. Now, as I said, I'm not going to get into the particulars of the litigation. Director Dietz can bring this group up to speed on that. But I will note that in this area, because of the Home Rule Amendment, the General Assembly has to walk a narrow line. If the General Assembly passes a local bill that targets a particular city or county, then the Home Rule Amendment, as I said, requires local approval, which is unlikely to happen with the sorts of bills that we're talking about today. But if the General Assembly tries to expand the bill into an act of general application, then obviously it affects people across the state and is likely to be harder to pass. So the challenge for the General Assembly is how to draft a bill that looks enough like a public act to pass Home Rule Amendment muster, while still applying to just the targeted jurisdiction. And as we've seen with the results of some of the cases that have been brought in Davidson County, that is not an easy task for them to do. So let me stop there and turn this over to Director Dietz, who is going to give an update on what some of these cases coming out of Nashville, what has been going on with those.
General Cooper, thank you so much for your presentation. Director Dietz, I know you're joining us remotely, and we appreciate your presence with us this evening. Thank you very much, and we're very much so looking forward to your presentation as well.
Thank you, Mr. Vice Mayor and members of the council. First, let me apologize. It was until 11:15 this morning, Central Time, my plan and intent to be there with you in person. And then the mayor called me into his office and he had a different plan for me today. So I needed to be here for a 2 o'clock meeting that he was holding. And so I apologize that I'm not there in person. I fully expected to be, but it's just the way it goes. And I'm sure you can all understand that. But I appreciate your time, appreciate your interest in this. As my good friend Bob Cooper has said, these are fundamental constitutional issues. The way I look at this, what happened in the legislative session, not the special session, but the main session in the first 4 months of 2023, we saw an unprecedented level of attack on one local government. And I don't want to get into the politics of that because I don't view this as a Democratic or Republican issue or a political issue. I view it as an issue of local control and a matter of fundamental constitutional rights that local governments have, not to be micromanaged by the legislature. So the legislature passed a number of bills targeting Nashville. And so we have filed suit over 4 of those. There was one bill where they appointed some state officials as ex officio members of our convention center board. We did not oppose that. In fact, we welcomed having the comptroller and some other state officials on that board as ex officio members. We're looking for that kind of relationship with the state. But there were 4 bills that were enacted that we strongly believed were targeted solely at Nashville and violated our constitutional rights. The first one was directed to the Metro Council. Our Metropolitan Council has 40 members. It's one of the largest in the country. There are 35 district members and 5 at-large members. It's a large council, and it's subject to legitimate debate whether or not the council is too large. But we believe that issue should be decided by the voters of Nashville, not by legislators from far-flung areas of the state. Well, the legislature adopted a bill that required, and the way they defined it, it only applied to Nashville. They required a bill that required Metro to reduce the size of its council from 40 to 20 and to do so immediately, even though we were in an election that had already started. We had candidates for council who had filed qualifying papers, had appointed treasurers, had started to raise money, and in fact were campaigning. And the general, this is a nonpartisan race. The general election was in August, and any district where there needed to be a runoff or at large, the runoff was September 14th. And so we argued, we filed a lawsuit saying that this violated the Home Rule Amendment because it targeted only Nashville and was intended to target only Nashville. It could not apply to any other local government. And we asked the court for a temporary injunction. As you may know, a few years ago, the legislature, in particular with cases that were brought by Nashville and heard by Nashville chancellors, they didn't like the opinions that were coming out. So the legislature changed the law so that if we or anybody else, if we challenge an act of the legislature based on constitutional grounds, Tennessee constitutional grounds, it goes in front, we file in Chancery Court in Davidson County, and we get a chancellor by random draw. And then the Supreme Court appoints 2 additional judges, one from East Tennessee, one from West Tennessee. And so we went in front of this 3-judge panel with a local chancellor plus 2 judges from East and West Tennessee, respectively. And we argued our case, and we very promptly got a ruling 3-0 that as applied to this year's election, the bill was unconstitutional. It violated the Home Rule Amendment to the Tennessee Constitution. The court did reserve the issue of whether it could apply going forward, and only one judge ruled that would have ruled immediately that going forward for the next elections, which will be 2027, it could not apply. But we are going to argue that issue with cross motions for summary judgment that will be heard in, I've forgotten, it's April or May of next year. which will give us a chance to get a ruling and have a final decision in plenty of time. We are optimistic that we will ultimately prevail on that part as well for the prospective application of that statute. So we won. We had an election this summer where 40 council members were elected, and they had their first meeting on October 3rd, and they're meeting in due course now. The second lawsuit that we filed was based on the legislature passed a bill that simply amended our charter. It's almost like they pulled our charter up and did track changes to our charter. This goes back to 10, 12 years ago when there was a Save Our Fairgrounds movement in Nashville, where people were concerned about losing the state fair and the flea markets and the stock car racing that was going on, saying we want to preserve all that. And so they proposed a Save Our Fairgrounds amendment to our charter. There was a referendum and it passed overwhelmingly. And what that amendment did was to require any ordinance that called for the destruction of any part of the fairgrounds, instead of just needing a simple majority, 21 votes out of 40, it required a supermajority of 27 votes. And in the background, what was happening was Bristol Motor Speedway was coming in with a proposal to bring more NASCAR racing to Nashville. They needed to destroy the grandstand, the historic grandstand around the racetrack. And they realized they could not get 27 votes for their proposal, which they hoped to get through the council, the old council, which had its last meeting on August 15th. So they're up against this supermajority and don't think they have the votes. So they went to their legislators, the state representative from Bristol, the state senator from Bristol, and said, hey, we want you to do this amendment. And the amendment impacted metropolitan governments with, population of, certain sizes, and essentially it only impacted Nashville. This was a unique charter provision. I'm sure you don't have a charter provision that talks about demolition of fairgrounds or any other Knoxville-owned property. It only applied to Nashville. And so we, again, filed suit, said you're violating the Home Rule Amendment. We get a 3-judge panel. And once again, we get a ruling 3-0 in our favor. The state did not appeal that ruling. The state did not appeal the ruling on the Metro Council as it applied to this year's election. So part of the council case is over. The fairgrounds case is over. We won 3-0. The third case was our lawsuit. It's been a very busy year for Metro Legal, and frankly, we've had General Cooper helping us every step of the way. And so our third lawsuit was when the state essentially stole our airport authority. In 1969 or 70, the state passed enabling legislation encouraging local governments to create airport authorities to run their airports. And the thought process at the time was airports were critical to economic development, and they needed to be run professionally and not be subject to political whims or, who's the mayor, who's in charge, to create an independent business-like authority to run the airport. And so, like many local governments, Metro created the Metropolitan Nashville Airport Authority. Under state law, our authority is an agency and instrumentality of the metropolitan government. It's ours. We own it, we control it, and under state law, the mayor appointed all of the board members subject to approval by the Metro Council. Well, the state came in and said, no, we're going to take over your board. We're going to vacate your board. They're out of office as of July 1. And we are going to install an 8-member board where the governor gets 2 appointments, the lieutenant governor gets 2 appointments, Speaker of the House gets 2 appointments, and the Metropolitan Nashville mayor gets 2. But they took over control of the board, which under government accounting rules literally means instead of it being a component unit of the metropolitan government of Nashville, it became a component unit of the state of Tennessee. They literally stole our airport. And so it did not apply to any other local government. And so we argued again, home rule amendment, and we added arguments under the equal protection clauses of the Tennessee Constitution, which are very similar to the equal protection clause arguments you would see under the 14th Amendment to the U.S. Constitution. So once again, 3-judge panel. We argued cross motions for summary judgment on October the 6th, and on Halloween afternoon, about 4 o'clock, we get an opinion, unanimous. Again, 3-0 in our favor. Saying this bill violated the local legislation clause of the Home Rule Amendment. It violated the Ripper Bill of the Home Rule Amendment because it ripped our appointees, our officials out of office, and it violated the Equal Protection Clause. So we had 3 judges across the board unanimously agree with all 3 of our arguments. And so as of this Monday of this week, our board was back in place after being in exile for 4 months. And they're now beginning the process of figuring out what happened in the prior 4 months. It's unclear what the state will do with this. Their deadline to appeal does not run until November 30th. So they have plenty of time to file an appeal if they choose to do so. But we're hopeful that even if they do appeal, that the appellate court and potentially the Supreme Court will see how strong this opinion was. 34 pages approved by judges across the state unanimously. And one thing I want to point out is that in these 3 cases that we have won unanimously, the chancellor from Metropolitan Nashville runs as a Democrat. And so we had a chancellor from Nashville who was a Democrat. In each case, the other 2 judges were appointees of Republican governors. And so if you're counting political judges, and I don't do that because I believe 9 out of 10 judges or more, once they put on that black robe, they don't really look at politics. They do their very best to follow the law. I just trust our judges to do their very best to follow the law, regardless of their political leanings one way or another. And so that's giving us some hope if we do get to the Court of Appeals or even the Supreme Court, because we have bipartisan panels with judges from across the state, highly esteemed judges, these in fact are judges picked by the Supreme Court to sit on this panel for this important case. We're hopeful that we will prevail on appeal. The last case we filed, the 4th case, is a case where with our sports authority, which owns the Titan Stadium, our AAA baseball stadium, our new soccer stadium, which is the largest single-purpose soccer stadium in the country, and Bridgestone Arena, where the Predators play. So our sports authority's been very active and very successful. They passed a law that will go into effect if we do not win this motion for an injunction on January 1st. And with our 13-member sports authority, they vacate the entire board and say the state will appoint 6 of the 13, and then 7 members of the existing board will be reappointed, but through the statute, they pick which ones. So they are vacating the entire board, and even though they're reappointing 7 members that were on the board we appointed, they don't give us the chance to say, okay, if we only have 7 seats, here's who we want. They picked, by virtue of tenure, who's going to be on that authority. So we are in the midst of our briefing on that. We have our argument on our motion for temporary injunction on November 29th. And we are going to encourage the panel to give us an opinion before January 1, before the board changes over. So we think we're very optimistic because we've won these arguments 3-0 now in 3 different cases. And for me, every time I talk to the media, I talk about, of course, we're grateful for the courts and that we are winning these cases. But the main thing is we want the state legislature to understand what the constitutional limits are so that they cannot decide to come in and tell Metro Nashville or the city of Knoxville or Knox County or whoever how to run their local government and pass laws that apply only to that local government. So we're hopeful that the relationships are being recalibrated where, frankly, they respect us because it was clear in this last session they just didn't respect. They didn't want to hear what we had to say. They were upset with us, and they just wanted to do things to target Nashville. So in any event, we've been really, really grateful that the courts have paid attention. Very encouraged that we have won 3 cases now unanimously. We're hopeful on the Sports Authority. One footnote, like Knoxville, we had a community oversight board, and the state law changed the powers and the composition of those boards. But the state law applied to Nashville, Memphis, Chattanooga, Knoxville, all of whom had boards, and it applied prospectively. So we chose not to file a lawsuit over that because we did not believe we could meet the guidelines outlined in the case law that Bob Cooper just described. So we chose not to litigate that. And I got some severe criticism from supporters of the COB, but we're going to be very careful in what lawsuits we file, and file lawsuits only if we strongly believe we are right on the constitutional law. So I'm sorry for taking so much time, but we are hopeful that we'll keep these wins on appeal if the state does appeal, and hopeful that the legislature going forward will not do some of the things they did to us this year. Thank you.
Thank you, Director Dietz. We really appreciate your participation remotely. We understand being called away and having something you have to handle, so that is understandable, but we do appreciate your time and discussing what's going on in Nashville today. Ms. Nguyen, welcome. We are really looking forward to your presentation this evening as well. Thank you for traveling to visit with us today and taking time out of your day and your week to come visit with us. I'll turn it over to you now. We're all very interested in your presentation as well. Thank you for being here.
Thank you, Mr. Vice Mayor, members of the Knox County Council. I am honored to be here with my good friend Bob and with Wally, and I'm here because of a presentation these guys did on a call I was on. I serve as the Davidson County Clerk, and let me open my comments by saying that most, if not all, of the work that I do every day in my line of work is dependent on our Tennessee General Assembly and the legislation that they pass enabling me to do this work. So I respect what they do most of the time. But in the instance of the legislation that was passed impacting Nashville, I couldn't sit by and not at least stand up for what I believed in as a citizen of the county. I'm an elected official, but I've also lived in Nashville most of my life. I was in the city of Nashville when we became a metropolitan form of government. I recall the history that caused our charter to be created, the charter that called for us to have 40 members on the city council, and the fact that it didn't pass immediately. It took several votes for us to get to the place where we chose the size of our council. And what we wanted at that time, people in the community, was a council that reflected who Nashville was. We chose 40 members because we wanted to have representatives on our city council who looked like us. So when I heard the presentation from Wally and Bob about the fact that there was talk to reduce our city council down to 20, I'd already been following the legislation, been listening, and was pretty upset, but that call gave me the opportunity to stand up and to speak out. And that's the thing, as a citizen, I just believe that we have to always stand for what's right. The citizens in Nashville had voted at least 1 or 2 times on the size of our city council. We had decided that we wanted our council to remain a 40-member council. So having it reduced to 20 was going to impact us, I believed, in a way that was not going to be beneficial to average everyday citizens. When I think about what it costs to run an election these days, you don't run elections on pennies. You need money to do that. And so I believed wholeheartedly that had our council been reduced to 20, citizens, average everyday citizens, neighborhood advocates that I had worked with over the years were not going to get elected to those offices. It was going to be individuals who had the backing of the business community. So I stand up and I speak out against the legislation that was passed targeting Nashville, mainly because of the city council legislation, remembering that at the time that legislation was passed, we in Nashville were going to be celebrating 60 years as a metropolitan form of government. But what we were also going to be doing, had that legislation been successful, was watching that state legislature roll back 60 years of civil rights gains. And I just believe that it was important for me as a citizen to stand up and speak out. Thank you for letting me share that with you today. And Bob and Wally, thank you for what you guys do. Thank you for all that you do to serve this public.
Thank you so much. That ends our presentations this evening, council members. It's now time for council questions and discussions. I wanted to remind my colleagues that our guests today are not familiar with anything that is directly occurring in Knoxville or may occur in Knoxville. They're here to talk to us in general about what home rule is and what their experience has been in Nashville over some of the legal cases that they've been involved in. So we certainly welcome them being here. But please try to keep your questions to a general discussion about home rule and not specifics, because they won't be able to share any answers or insight with you. All right. Do we have any questions? Councilmember Ryder.
I'm trying to think generally. Sorry, I think we're all up here, wheels are spinning, trying to stay within the bounds. I'll direct this to Mr. Dietz or Mr. Cooper maybe, but Ms. Nguyen, you also may have comments. I don't know who the correct person would be. How many active litigation cases are there right now regarding home rule? It's more than one. You have several things that are in litigation, correct?
We filed 4 cases coming out of this legislative session.
Okay.
And prior to that, we had litigated the voucher case, the ESA case, that applied at the time only to Nashville and Shelby County, although that litigation has now concluded. Active cases that we are involved in, there are 4, except the fairgrounds case is over. We won it. There was no appeal. It's over.
The fairgrounds, okay.
The fairgrounds case is over. We won 3-0. They cannot amend our charter. and that case is over. The Metro Council case, we won the injunction as it applied, the statute applied to this year's election, and we will argue in the spring in front of that three-judge panel whether we can have the act declared void as it would apply to the elections in 2027. So that case is still open. That one's open. The Metro Nashville Airport Authority, which we just won on October 31st, 3-0. It is now subject to an appeal, and we'll know by November 30th whether the state appeals. So that case is still open. The third case is the Sports Authority case, which is being argued on November 29th. So we have one case which we won is over. A second case we won for this year, but the rest of it's still up in the air. So that's a partial victory. And the third case we won, we could go up on appeal. The fourth case is pending before the three-judge panel on November 29th. So those were the four cases we filed.
And the fairgrounds is from a previous legislative session, not in the current four, correct?
It was 2023. What happened was Bristol Motor Speedways came in with a proposal that our mayor was in favor of. And it was to renovate the fairgrounds, and they were hoping to have their proposal to enter into a lease for the speedway portion of the Nashville Fairgrounds, and bring NASCAR to Nashville at least once a year or every other year, and then run other races through there as well. So that was very much an active proposal. They became concerned they were not going to get to the supermajority threshold that the charter amendment required. So I think it was in April of this year, as the legislature was getting ready to go out of town, it was towards the end of the session in April, they passed that law affecting the fairgrounds. So all of the four cases I've talked about all came out of the legislative session between January and the end of April this year.
Okay, so have you, and we're on timers here, I don't know if you can see that or not. We have a 5-minute timer when we speak, our rules. Have you had other sessions in the past, other than this most recent one, where you've had multiple or past legislative sessions, have they had issues where you've had to file litigation?
Yes, and I'll ask General Cooper to speak to some activity because he was involved as law director. He served prior to my coming in, and he had litigation that he filed. So Bob, you want to take that one?
No, happy to. So what Wally is referring to is the bill passed in 2019, which created the Education Savings Account program. That bill was drafted so that it only would apply now and in the future to Davidson County and Shelby County without further amendment. And so we challenged that as a violation of the Home Rule Amendment. The fact that a bill applies to only 2 counties instead of 1 county does not exempt it from Home Rule. And we also challenged it under equal protection. We prevailed in the Chancery Court in Davidson County. That was prior to the statute that Wally's talking about that created 3 judge panels for constitutional challenges. We prevailed there. We also got a unanimous affirmance from the Court of Appeals. Then it went to the Tennessee Supreme Court. We actually had to argue it twice because one of the justices who had heard it the initial time passed away before an opinion was issued. And since the court was at that point deadlocked, then it had to be re-argued. And the court 3-2 overturned the lower court decision. Obviously, we think on a too narrow ground that the statute applied only to local education agencies, not to the county or city that funded them. But that is the interpretation. We don't think that applies in the cases that we have been litigating, and obviously the courts have agreed with us on that so far. One point I would make about that ESA lawsuit and the ESA bill, that bill passed by only one vote in the House of Representatives, and that was after several deals were cut. The bill initially applied to multiple jurisdictions, was a bill of general application, but various cities and counties were exempted in order to get votes of additional legislators, so that it was only ultimately narrowed to those two. But any comfort that a legislator may have taken from having their jurisdiction carved out obviously is short term, because as we know, there is a bill coming up in the upcoming session. Well, it's already been expanded to a third jurisdiction, and there's a bill coming up that will make it a bill of general application across the state. To me, what that shows is the local governments really need to work together from the start. Don't assume that just because you get carved out initially that whatever is done is not going to get expanded at some future time.
I appreciate you guys' time. I'll defer to my colleagues for now.
Councilmember Smith.
And thank you for your time tonight. I know you either drove here or spending time with us tonight. It's very important for us. It seems to me that one of the common themes of the legislation that you're challenging is consolidating representation, meaning a less diverse representation. I think Ms. Nguyen, you mentioned this a little bit. Could you all expand upon, some of that is some more obvious, other aspects of that may have a ripple effect that are more nuanced, but can you talk about the consolidated representation and the lack of diversity of representation in each of these cases, and maybe some things that aren't so obvious to the eye, and what impact it has on the representation of the community?
Again, my passion about what was happening with the reduction of the size of the council went back to why we had that size of council in the beginning, going back all the way to the charter that created the metropolitan form of government. It was votes that were passed, votes that allowed the charter to be created, that included conversations with our greater community about what our council would look like. So to have 35 council districts where you would represent people from across the broader community, that's why I was disturbed about the reduction of the council again, and because just a few years before, there had been a vote put to the citizens of Nashville challenging the size of the council, asking us if we wanted it reduced, and the vote was decisively that the citizens in Davidson County were satisfied with the size of our council, and we wanted to keep it that way.
I would, Councilmember, I would point out that if you're looking at the Airport Authority legislation that was passed, it took the Metro Airport Authority from a body that consisted only of residents of Davidson County, the county most affected by the operation of the Airport Authority, and reduced it to where the statute only required, it could be more, but the only requirement for local representation would have applied to 3. So that could be theoretically a significant reduction in the representation of, for example, people who lived close to the airport and most affected by its operation. Much more limited availability to be on the authority.
Thank you.
Councilmember Testerman.
Thank you, Vice Mayor. And thank you all for being here. This is definitely helpful information. And this kind of piggybacking on Councilmember Smith's, I'm just curious in a little bit more of a deep dive of the Airport Authority, but also the Sports Authority. You know, not as much. I'm just curious what some of the more underlying grievances of the General Assembly were as it related, and if y'all stated this, but I didn't get it, but with the airport, but also with the Sports Authority, again, with such, so much expansion of, you know, the sports in the Nashville area. So I'm just curious about what was it that the GA saw that really felt the need to go after these two bodies specifically?
We're going to defer to Wally on that.
Yeah, I'll take a shot at that. So I was on the Hill when these bills were being debated. I was watching on my computer screen, and time after time again, members of the Davidson County delegation asked the bill sponsors, why? Why are you doing this? What is it about our airport authority you believe you need to take it over? What is your criticism? And they had none. They had no criticism at all of how our airport authority was operating. Our airport authority had a very high bond rating. It was growing. We were attracting new airlines. They are in the midst of a major expansion. They just completed a major renovation, and our delegation kept asking why, and there literally was not a single criticism of the airport authority and how they were doing business. They said, in fact, essentially, well, you know, the airport's growing so much, we just think we should be involved. So that it's almost like we're penalized for doing a good job. If you do a really good job, oh, well, we're going to take you over. It seemed counterintuitive to me. And that's one of the things that the court pointed out was that they had no rational basis to do this. And that came up in the equal protection claim argument because all they had to do was prove there was some rational reason to do it, and the court found as a finding of law that the legislature failed to articulate any concern about the sports authority or any reason to require the legislation. And in fact, the same is true with the sports authority. Our sports authority over the last 25 years has been unbelievably successful. 25 years ago, we didn't have any professional teams here. We've got the Titans, we've got the Predators, we've got AAA baseball. We have an MLS team with one of the highest season ticket sales of any of the teams in the MLS. And again, they had no criticism at all of the sports authority. They just said, oh, we just need to be involved. So there were reasons that had nothing to do with the business operations or the success of either one of these authorities.
So essentially, and I ask because those are two exposure areas for us as well. And, you know, but even just sort of off the record comments, it sounds like there was nothing that pointed to any rational reason. I mean, correct?
Not a single rational reason or legitimate or any criticism at all, whether it was legitimate or not. There was no criticism of anything that either one of these authorities had done. Zero. No criticism. We just want to take over.
If I could add something to what Wally was saying, which is right on point. The sponsors of the bills, let's start with the Airport Authority, gave really a couple of reasons why they felt that the state needed to have control over the Nashville airport. One is that it was drawing in so many passengers from outside Davidson County. And the second is the state gives money to the Airport Authority. That is, of course, true, but The Tyson Airport draws people from all over East Tennessee and receives money from the state. The Chattanooga Airport, the same. The Memphis Airport, certainly the same. And so, the court in its opinion points out that, well, those are not reasons to distinguish Nashville from any of the other metropolitan airports in Tennessee. And the same argument was made with regard to the Sports Authority. The state pointed to the fact that it was putting, several $100 million into a new Titan Stadium, and therefore they should have 6 seats on the Sports Authority. Well, the state is also putting several $100 million into Memphis sports facilities and helping Knoxville with a baseball stadium. So again, that is not a factor that can distinguish Nashville from any of the other cities. So I think your conclusion is right on point.
Okay, thank you for that.
Thank you, Vice Mayor. First, let me thank our guests for being here in person and remotely, and a big shout out to CTV for this broadcast that I was able to listen to while I was stuck in traffic on my way here. Want to first say that this is disturbing, what we're seeing that's happening. It appears that this is an unfortunate trend that I think is prevalent, not only a trend but a threat to local democracy and governing bodies. I would gather to say that there are underlying motives that drives these decisions and that want to take away the power and the voices of the legislators locally, who we all sit around this table and we're the voice of the people in our city and in our counties. And so, but we know that this comes not just out of nowhere, because someone has to bring the legislation to the table at the General Assembly. And when we look at some of the things that we feel, that I personally feel are a little divisive, there are people who go rogue and are not doing this for the people, because this is not what we have heard, some of the things that have come up from the state that are coming down to us that our constituents here in the city want to see done here. And so I applaud your efforts and the fight that you're in right now to be able to make sure that the people are represented at all levels. If it could happen to one airport, it could happen to any. And so I feel that, again, I would just want to personally thank you all for standing up for what you feel is right and that represents the people that you represent in Davidson County. Thank you.
Thank you. We appreciate that. It's been interesting. Everywhere I go, I have people come up to me, some I know, some I don't know, and just thank me and say, thank you for fighting. The people I do know, some are Republicans, some are Democrats, some are independents. The thing they don't like is the state telling us how to run our local government. They don't like that. And they appreciate the fact that we are fighting back. And one of the reasons we wanted to visit with you today is to share our experience and some of the hope that we have now that's coming out of this litigation. We believe there are constitutional constraints on what the legislature can do. Thank you. Thank you for your comments. We all do appreciate that.
You're welcome. And also, before my time is up, I want to turn to Mr. Frost, because the term metro government is not new to us here in Knox County. There were many, many years ago, I think within the last 15 years, I don't know if you were serving on county commission at that time, when there were some rumblings about Knox County considering metro government. Do you recall that, Rob? Was that during your time?
I believe that was before my time, Councilmember McKenzie. I believe metro government proposal for Knoxville and Knox County has been on the ballot 2, maybe 3 times. Dr. Lyons is telling me 4. I trust the man. And it's lost every time, so I think the political will to do that has subsided.
I just wanted to acknowledge that it's not, that conversation's not new to us, but this body, we've never encountered it until now. Thank you.
Thank you. Councilmember Ryder.
Yeah, so to our guests, I'd like to get into the nuance of something specific. One thing I wrote down that you said in a couple of different times is that this legislation that comes across that would be a state constitutional violation of home rule is when it targets one government. With a fair repeating of what you said.
Yes, that if the legislation targets one government, and again, there is case law out there that has also struck down legislation that, say, targets two. You know, it's not a free pass if you just throw one more local jurisdiction into the bill. But yes, if it targets a particular city or county in its governmental or proprietary capacity. But if you look at the definition of those two terms, that essentially covers everything that a city or county does.
Okay. Because specifically, I think you've just answered my question, but when you were talking about the educational savings account bill from 2019, you said that applied to, I believe, 2 counties.
That's correct. It applied in Davidson County and Shelby County.
Okay, and so you did file litigation on that one?
We filed both Davidson, both Metro Nashville and Shelby County joined together to file an action challenging that under the Home Rule Amendment.
Okay, I think it's important to note, and so you won? And
We won at the trial level, we won at the Court of Appeals, we did not win at the Supreme Court.
so where does that stand? Is it still?
Well, as a challenge under the Home Rule Amendment, that case is over.
Okay.
There is still litigation over whether or not the bill satisfies the Equal Protection Clause.
Okay. That is the one you said passed by one vote in the House?
Passed by one vote in the House.
And I believe Mr. Frost here reminded me that was under Cassada's tenure as Speaker.
He was the Speaker at the time.
Okay. What were the qualifiers, or what was the arguments for it not passing at the Supreme Court level?
I mean, what was the rationale that the Supreme Court adopted?
Yeah, what was their opinion?
The Supreme Court said, based on the language of the statute, that it was a program that applied to the local school system, not to the county, and that the local school system doesn't fall within the Home Rule Amendment.
Okay, thank you. I just think it's food for thought and something to think about in regards to our own issues. So, thanks.
Thank you. I just was going to ask the panel, surely these instances are not limited to Nashville or Metro Nashville government. Are there other examples of actions that have occurred elsewhere outside of Nashville?
Certainly, over time, if you go back from 1953 forward, these cases have arisen out of all parts of the state. But this most recent wave, the ESA legislation from 2019, and then these bills passed this last session, those have been targeted specifically at Nashville and, with the ESA case, Shelby.
Has there ever been any activity in Chattanooga over these types of issues?
There's a significant case from 1979 involving the Chattanooga-Hamilton County Hospital Authority creation. And there was a lawsuit over that challenging the constitutionality of the acts that created it. It's a fairly complex transaction. The court ultimately upheld it. But that's the only case I can think of, at least that went up to the Supreme Court level involving Hamilton County and Chattanooga.
Okay, thank you. Ms. Nguyen, is there, in your experience, is there any economic cost to state action on local matters to consider? You know, specifically, I was thinking about administrative costs. Is there anything to be concerned with, you know, that kind of state discussion versus a local discussion and economic costs?
I don't know that I could answer that question. I'd probably defer to Law Director Dietz as to whether or not that's something that he might be able to answer.
Director Dietz?
Vice Mayor, there is a direct economic cost. This litigation has been extremely expensive for us. We have engaged outside counsel, Mr. Cooper, General Cooper and his firm, to assist us because we did not have the capacity in-house at Metro Legal to handle all of these cases on our own. While their bills are eminently reasonable and justifiable, it's been a significant amount of money. We've had to pay expert witnesses as well. Plus, we have had multiple lawyers inside Metro Legal devote a significant part of their time this year to these cases. There are other impacts as well. Take the airport authority, for example. Our board was in exile for 4 months. In the meantime, the state-appointed board ratified over, it was several $100 million worth of contracts, over $100 million every month. They raised the salary of the CEO by more than 50%, from $390,000 to $600,000. That's a cost that's now going to be borne by the airport authority if, in fact, if it holds up after this transition. I think in terms of the ESA case, there are burdens that are placed on Nashville and Memphis. There were burdens placed on that to administer that were economically disadvantageous for us, and we're looking into that a little bit more deeply as we go forward. I think the thing that concerns me most is it creates a climate of uncertainty, which ultimately I believe may result in a loss of business confidence. And if Metro Nashville or any city or Knoxville is repeatedly under attack by the state, and you're a firm that is looking at Nashville or Knoxville to relocate, why would you choose that city as opposed to going to some other city where you don't have this sort of battle, constitutional core governance issues in that battle? So it's hard to quantify. I can't say that we lost a particular business relocation because of it, but it certainly is disadvantageous to the image that we are trying to promote. It's better for all of us. It's better for the state. It's better for Nashville if we are singing off the same page about some of these core issues. We can disagree on policies about what's the best education policy, what's the best, policy where the state has a lot of control, if not exclusive control. But when it comes to these structural issues, I think there will be an economic cost to the city.
Thank you. Councilmember Ryder.
Yeah, just one other thought. This is specific to one of the things you brought up. That is outlandish, the raising of the salary for the airport executive. I assume I may have that title wrong. Airport flight is federally regulated. There's FAA. Have there been federal issues, or are there federal implications to some of the interruptions with the airport authority?
That's a great question, and it's a really interesting issue.
I'm reckoning it could be a 30-minute or better conversation, so I'll let you
Well,
do what you can.
And I'll try to keep it really short. The CEO and the sponsors of the legislation got legal opinions saying the FAA had nothing to do with this, that they had no role in this change in the board at all. I looked at the federal statute. I used to practice law. I still am licensed to practice law in DC.
I hope so, but keep going.
I looked at the federal statute and I go, I don't think that's right. So I flew to Washington. I retained the former general counsel to the FAA to assist us in dealing with the FAA. I retained a former deputy administrator of airports at the FAA, who had been appointed first by George H.W. Bush and then by President Trump. And we went to the FAA and said, do you have any idea what the state is getting ready to do? And they were angry because they had not been consulted at all. And the FAA must approve a change of ownership or management of the certificate holder of the airport. And they had not been consulted at all. And so the FAA wrote a scathing letter to our board and CEO saying, we cannot believe you've not told us. You've got to give us answers to all of these questions. And so as our board is going out of existence in June, the FAA issued a letter saying, pursuant to a pre-existing policy where this same issue had come up in Jackson, Mississippi, and Atlanta and other airports. Pursuant to our existing policy, if there is litigation over ownership and control of the airport, the FAA will continue to recognize the pre-existing board. So we got a letter saying, no matter what state law says, we recognize the Metro Board. So my position is the Metro Board never went out of existence. It was in exile. But it's just one of those, it's just one of those things where the part of the collateral damage is that the FAA, we're going to have to rebuild that relationship. I'm pretty sure we can very quickly. But we're going to have to rebuild that relationship. So yeah, the FAA had a lot to do with this.
Thank you. I appreciate that. I appreciate Councilwoman McKenzie's kinder version of saying that some of these things are very concerning. That is, it's like a threat to democracy. I want to use some more inflammatory words. These type of actions point to instability. It's things that you see associated with, I'll just restrain my words because I don't want to incite, but this is just not what you expect from democracy. And so it's very concerning. And I think there's a lot of people that there's not enough people paying attention, and there's a lot of people grossly concerned every time we get closer to a legislative session, and each legislative session raises more concern and uncertainty amongst the few that are paying attention. So I wish, everyone who is listening or watching this, please let people know, because this is the kind of stuff that happens and gets worse because you aren't paying attention. And it happens before you know it, and it's over and it's beyond you, and you're too late, and that's grossly concerning. And it's coming from people who say that they don't want the federal government to tell them what to do. So it's government overreach.
Thank you. Director Dietz, you had mentioned that you're careful about when you're filing lawsuits. Could you discuss any parameters that you use to evaluate yourself or pause as you're considering the potentials for pursuing litigation?
Thank you, Vice Mayor. Sure. The first analysis is, do we have a claim? Do we have a claim that we believe is grounded solidly in the law? And so that's where we start. That sounds simple, but I've been asked multiple times this year to file lawsuits simply as a form of protest because we don't like it. And I'm not going to do that. I think our reputation with the courts, our reputation is really important. When we go to the court, I want the court to know that we're not there as a form of protest. We are there because we believe our constitutional rights have been violated. So that is the first and overwhelmingly the most important factor. Do we believe we have a constitutional claim? And so far, the courts have agreed that we are right, that we do have a constitutional claim. And so that's been very gratifying. Again, I referenced the Community Oversight Board because I have friends on that board. A lot of people I'm very friendly with were strong supporters of that board. They were extremely angry about that board being cut back in terms of its authority, but we didn't have a good case. And I hated to bear that news, but we didn't. Then there was another case that I mentioned this before, the convention center case, where our convention center was the only one affected. But the net result is that we have the comptroller and other state officials on that board. Um, and we decided that was actually helpful to Nashville. They were on the board as ex officio members. They did not take the place of any of our board members. And to have that sort of interaction between high levels of the state government and one of the economic engines in Nashville, that convention center, is hugely successful and very important to our finances, the motel taxes, the restaurant taxes and all that, the promotion of tourism. So we welcome that. We probably could have sued over that bill, but we thought, well, that result is actually good. And so we look at all of those factors, and we look at our internal capacity. And if we do not have sufficient internal capacity, then the question is, do we go outside? And these issues were so important, we decided to spend the money to retain outside counsel. So all of those factors come into play. And again, I just want to emphasize our goal here is to create a better working relationship with the state at the end of the day. We're not trying to antagonize the state for the purpose of antagonizing the state. We want to protect our constitutional rights, and we are sending this signal every which way we can. Yes, we filed these lawsuits because we felt like we had to protect our constitutional rights, but we do not want to be in this litigation time and time again, over and over, and we want to get to a different level of discussion where our concerns can be heard before it gets to this point. So we invested in this litigation this year because we believed it was existential. Literally existential. Are we going to let the state control the size of our council, take over our airport, do all of these things without fighting back? So at the end of the day, it was an easy decision. Difficult because it's created some turmoil with the state, but whether to file the lawsuit in these 4 cases, I never second guessed.
Thank you very much. Councilmember Thomas.
Yes, I simply want to thank you all for coming today and sharing your experiences with us. It's really been invaluable. We've all listened very carefully, and this will really help us put things into some context about our particular situation here. So really appreciate it. Thank you.
Well, we thank you for the time, and we stand ready to take phone calls to consult with you as needed as you confront your issues. Again, hopefully the state will be more mindful of protecting the rights of local governments. We'll see. We can only hope that this litigation has some impact to change that relationship. But we appreciate your time, and we are very grateful for your interest in this. We think every local government in Tennessee should be interested in this. It's not a partisan issue. It's not Republican versus Democrat. It's not that. It's a matter of protecting what the Constitution gives us which is the ability of local governments to do what they do without being targeted, specifically targeted by the state.
And I would just add to that, I very much appreciate your comment, but it really does, we're glad that you are receptive to this and welcome the opportunity to work with you, because any one lawsuit here as to home rule amendment is going to have an effect on everyone. But frankly, the best way to win this is not to be in the position where we have to bring a lawsuit, and that's for all of us to work together so that if one local government is threatened, then we all recognize that as a threat to everyone. Because, for example, as with the voucher litigation, just because it was limited to 1 or 2 cities doesn't mean it's not going to expand once there's a toehold, and that will be the same thing with others. So the more we can work together, I think the more successful we will all be.
Let me just say thank you to all of you for allowing us to come and share. We appreciate this opportunity, and if we can help in any way, just let us know. Thanks.
Thank you. And, you know, what I gathered from our discussion today was obviously specifics about home rule, but also the importance of relationships. And I know Director Dietz was just talking about that, you know, in his last remarks. You know, it's important for us to have good relationships with our state legislature. This council has worked very hard on maintaining good relations with our state representatives and our local representatives here. We've, you know, hosted, you know, joint workshops with our county partners, as well as having attendance from our state partners on subjects like mental health. Recognizing how important these relationships are, council has begun going and visiting and having a day on the Hill in Nashville to meet with our local representatives. So I'm glad that, you know, you all were so specific about relationships, because that's important. But then following up on what General Cooper was saying, those relationships are certainly important, but so are the relationships we have with other cities, other counties, other home rule communities, just other communities across our state, because any action on this is certainly impacting not only one individual community, but the whole. So I think relationships is an important piece. You know, it's been said a bunch tonight that this is not a partisan issue. Rather, it's really an issue that we all need to take up and we all need to care about. And so hopefully our discussion tonight can raise that awareness, not only here in Knoxville, but across the state. This really goes to core principles of our very democracy, as we've talked about this evening, as a fundamental, you know, constitutional issue. And so I think it's just critical that we're all engaged in this conversation. What I kind of began with thinking about, you know, the late Senator Howard Baker, but in 1966, he had said, "I believe that if the cities and counties of our state and the state itself are supplied with the practical authority to govern by means of their economic strength to carry out their programs, the tax dollar will go further, administrative costs will be lessened, greater flexibility and accommodation of the local problems will result, and the very essence of freedom and self-government will be reinforced and intensified." I think those were true in 1966, and they're true today. And so this workshop had a lot to do with those specific comments that he had made. What I would like to do is again thank our distinguished guests for joining us virtually and here in person. We really appreciate you traveling and spending time with us. Please, when you return to Nashville, let your colleagues know that Knoxville is interested in what is happening in Nashville. We care about what's happening in Nashville, just as we care about what's happening across the state. So hopefully you can deliver that message for us. Again, we really appreciate you all joining us this evening. Thank you for your time. And with that, this meeting is adjourned.